When spouses first separate, there are four main issues that we need to address. The first is who is going to stay in the marital residence. And this is important where the parties physically separated. They decide not to continue to live in the home together. The second issue is custody of any minor children. We have to arrange for each spouse to have appropriate time with each of the children. Number three is spousal support. Spousal support is to ensure that the spouse who is financially dependent, that means the spouse that is not earning as much money as the other spouse, has enough money to support himself or herself during the period of separation. And the fourth is child support. We have to make sure that the person who has custody of the children have enough money to support the children. So those are the first four issues that have to be addressed whenever a party is either contemplating divorce or just separation. Clients often ask whether they should file for divorce or whether the other spouse should file for divorce. And that depends on the facts and circumstances of each of the cases. Depending on who the client is, that will determine whether or not filing for divorce is a good idea or a bad idea. Let me give you a couple examples. It may be in my client's interest, and I may recommend to file for divorce, where the parties are separated but still living in the same house. For economic reasons, parties sometimes do not physically separate. They stay in the same house even though they want to start living separate lives. To establish a date of separation, we would file for divorce. Now, divorce filing presumptively establishes the date of separation. And date of separation is important in Pennsylvania because that's the day that we determine what's a marital asset and what is not a marital asset. So it is important to establish a date of separation, and if you're living in the same house, that's difficult to do. Another reason we may want to file for divorce is if I am representing a spouse who I am concerned may have difficulty getting spousal support. If you are the spousal support recipient, and I'm concerned that the other spouse may attempt to deny your request for spousal support, I may want to file for divorce. For instance, if my client has left the marriage for absolutely no good reason, if my client tells me that he or she has engaged in extramarital affairs or marital misconduct, I may want to file for divorce, because once a divorce action is filed, the other side cannot deny my client's request for support. The third reason I may want to advise a client to file for divorce is that I am concerned that the other spouse may attempt to dissipate marital assets. For instance, drain marital bank accounts, or drain retirement accounts, drain investment accounts. Or if I'm concerned the other spouse has a business and may try to sell the business without getting my client involved. By filing for divorce, I now have the ability to go to court and ask the judge to enter orders freezing marital assets, freezing bank accounts, requiring the other spouse to keep my client informed of any decisions of selling a marital business. So that's a reason for filing for divorce, particularly if the other spouse has the ability to use and dissipate marital assets. There are examples where I would not advise my client to file for divorce. The first is that it opens the jurisdiction of the court to both parties. So by my client filing for divorce, the other party has the right to come into court, ask for assets to be frozen, businesses to be monitored. Basically, the other spouse would also have the ability to take any action in the court that was necessary. I may not want to have that happen for my client. I want my client to continue to receive spousal support for as long as possible. And by filing a divorce action, I am limiting the amount of time that my client would be able to receive spousal support. For the first meeting with your attorney, it probably is a really good idea to contact the attorney and ask what the attorney would like you to bring. I can give you some general ideas about what most attorneys are asking for when they first meet with a client. They want to know what the marital assets are, so they will ask you to bring statements, bank accounts, retirement accounts, all the current statements for anything that currently exists in terms of financial accounts. They'll ask you to bring in any other assets that you have, a home, a vacation home, any cars or vehicles. They'll want to know about the incomes of the parties, so tax returns for the last 2 or 3 years would be important to bring in. Current pay stubs are also important. If there's a business involved, whatever documents are available with respect to a business, tax returns, financial statements. As the attorney gets more involved with your case, they will ask you for additional documents, but I think those are important to get the initial consultation started. You should also bring into your attorney documents which indicate what your current liabilities and obligations are. So that would be mortgages, home equity loans, credit cards, if taxes are owed to the IRS, any obligations that you and your spouse owe either individually or jointly, you should discuss those with your attorney as well.